Yeah, I'm going to talk about practical effects on collective bargaining in the Employment Rights Bill. And I want to really do that through the prism of three issues, one being balloting, one being the simplification of the recognition process, and finally I want to talk about the new right to access for trade unions. I suppose just to begin, it's worth reflecting on the commitments that were made when Labour came to power on the Employment Rights Bill, and particularly what was said in Make Work Pay was this concept of having legislation fit for a modern economy, to repeal the anti-trade union legislation of the last 14 years, and New Deal even went further than that and effectively said that we should have a legislative framework that is compliant with our international obligations, those that we have ratified with the International Labour Organization and the European Social Chapter. So I want to think also about whether we've achieved that in terms of what we've got, where it perhaps falls short of that, and where there are certain points that are still very much up for grabs, for want of a better word, because they will be determined by subsequent regulations and obviously the outcome of some very important consultations that have already been touched on. So just in broad terms here, you'll see from the overview, and this is based on the roadmap that was published in July, and I think as has already been inferred, perhaps that some of those timelines are already slipping. But effectively, what we think will happen is that the bill should get royal assent this side of the new year, and immediately on getting royal assent, we'll see the repeal of the minimum services strike legislation. Now, as you'll be familiar, that was introduced by the previous government, effectively in certain prescribed public services. Legislation was introduced whereby workers would be required to cross picket lines in order to make up a minimum service in a given industry. And there would be a duty on a trade union in those circumstances to make reasonable endeavours to ensure that any of its members identified there would turn up for work. Now, for a combination of reasons, one perhaps being the sort of impracticalities of that legislation and the fact that many employers thought it would be counterproductive to use those provisions, and then obviously as a result of a change in government, no work notices were ever served, and effectively that legislation sort of lay dormant. But it will be officially repealed when we get when the bill gets royal assent. We then move on to sort of what happens 2 months after royal assent, and in relation to that, there'll be many changes to notice requirements and a reform of the sort of framework of how industrial action works and how a union can call for it. So I want to say a few words about that. There will be also at that same time, there will be a new right for unfair dismissal in relation to industrial action. And then further down the line, there will be legislation that deals with any detriments workers are subject to as a consequence of taking industrial action. Although that legislation won't be within 2 months of royal assent and is unlikely to take effect until October 2026. In the second part of what I'm going to talk about, we'll talk about the simplification of the trade union recognition processes, which of itself is going to be subject to a further consultation before taking effect in April 2026, and the new right of access, which is subject to a current consultation with a view to taking effect in October 26. So industrial action, what's going to change when the bill takes royal assent? Well, many of the provisions of the Trade Union Act 2016 stand to be repealed within 2 months. One important tenet that won't be repealed immediately, though, is the turnout for 50% in any industrial action ballot. It had been originally envisaged that would go immediately, but it is now said that requirement won't go till the introduction of electronic balloting, which is expected sometime in April 2026. So that requirement will remain. One thing that will go, however, is the additional 40% threshold that is required in certain public sector services in support of a ballot. So in sectors like education, fire, transport. That will be that will be repealed within 2 months and will no longer be a requirement, making it easier to get a mandate for industrial action in those sectors. Now, the government had committed also to simplifying the requirements around what a union was due in order to call lawful industrial action. And as many of you will be familiar, the sort of current framework is very, very onerous with significant hurdles. Now, one requirement is to serve a notice of ballot before any ballot on industrial action can open. Now, that provision, the requirement to serve a notice of ballot, has been criticised by the European Social Committee because effectively there's arguments to say that that requirement is inconsistent with Article 11 in circumstances where you already have to serve a subsequent notice before you can take industrial action anyway. However, the government has decided that it is going to maintain a sort of overarching framework of the current regime, and therefore the notice of ballot will still be required. The one key change is there will be some simplification of the information that is necessary to give. And specifically, that is, there will be no longer a need to give numbers in relation to the lists of workplaces and categories that you need to set out in your notice of ballot. So that one area will be simplified. Other than that, though, the requirements around a notice of ballot will remain the same. And it will still be required to be given 7 days before any ballot opens. In relation to the ballot paper itself, again, we'll see a simplification of some of the requirements around that. The Trade Union Act 2016 introduced 2 requirements. One being that a union was required to give a description of its trade dispute on its ballot paper. And secondly, a union was required to give information around when it envisaged industrial action would take place, and also the types of industrial action if it was calling action short of a strike. So, for instance, work to rule, ban on overtime, etc. Those 2 requirements will go. So they will no longer be required within 2 months of royal assent. But other than that, your ballot paper will still have to give the questions, obviously, as to whether members are willing to participate in industrial action or not, and the warning that the warning caveat that is set out in legislation, informing them of their rights with regard to unfair dismissal. Although that wording will be slightly amended for reasons that we will come to. Notice of action, we're going to see a reduction from 14 days before, once a ballot closes, we're going to see a reduction from 14 days to 10 days. So some of you will remember before the 2016 legislation, it used to be 7 days. The 2016 legislation increased that 14, and the government has settled for 10 days under a new requirement. The overarching requirements within the notice of action remain largely the same, with the exception that it will no longer be necessary to give the numbers of workers in job categories. It will, however, still be necessary to give those numbers in workplaces. So just to be clear, in a notice of ballot, you don't give numbers in either workplaces or in categories. You just have to give the total number. But in a notice of action, you would still be required to give the numbers within each workplace. The requirements around the ballot result remain as they were. Effectively, there is a duty to inform both the employer and the employees of the ballot result in very specific prescribed terms. That stays the same. The life of the ballot, however, increases and will move from the current situation where we have 6 months to 12 months. So any mandate can continue for 12 months. So what is the intended impact, as you'll see from the slide there, was to reduce spurious legal challenges where an industrial action ballot has the democratic support of the workplace. Will we achieve that under the new regime? Well, I think there will be less scope to challenge industrial action ballots, because we do see, certainly in the work I do, I see a lot of employer ballot challenges around issues like numbers within certain job categories. I see challenges around how a trade dispute has been written on a ballot paper. So those sort of challenges should reduce. However, when I was preparing today, I was sort of thinking about some of the sort of key cases, if you like, where injunctions have been granted against trade unions on technicalities. And, you know, there's reference 3 there on the slide. And just in broad terms, one of those injunctions was granted against Unite as a consequence of how it communicated a ballot result and the sort of delay in doing so. The British Airways case was around trade unions, including workers in its ballot, who it was alleged that it should have known would be leaving the employer on the grounds of redundancy before the industrial action commenced, and therefore the ballot was unlawful because it had afforded the opportunity to those members to vote. The final case there was in relation to quite technical provisions relating to prior call, which is where it is said that it's unlawful. Any subsequent industrial action is unlawful if there has been an inducement by a trade union to call action before the notice of action was to take effect. Now, I don't think any of those cases would be decided any differently as a consequence of the bill. So while some technical challenges will fall away, I think it's important to sort of stress today the importance there will still be around data entries, around recording carefully the sort of categories and the workplaces in which members work, and that kind of painstaking research that has to go into ensuring that a ballot is correctly run. So it would be wrong to say that it's sort of going to be plain sailing going forward in terms of taking industrial action. That work will still need to be done. Likewise, the kind of discipline around all the communications that come out in a ballot period to ensure that no one induces any action before the actual official mandate has been secured and the notice of action served for when the industrial action can officially begin. All of that will remain the same. So yes, definitely some changes that will hopefully reduce technical challenges, but not a wholesale sea of change. Just very quickly on this one, one provision in relation to the picketing will change once the bill takes effect, and that is that there will no longer be a requirement to appoint a picket supervisor and the duties that fell under that, because again, they were introduced by the 2016 Act, and they will be repealed. The detriment for taking industrial action is a really important change, because for many of you will be aware, there's been no protection for workers who are subjected to a detriment for taking industrial action. And that is long thought to be a provision that is inconsistent with Article 11 obligations. Unison ran a case on this point to effectively say that the way that the current legislative framework is framed is inconsistent with Article 11, because in broad terms, what 146 provides is that you are protected from being subject to a detriment, but only if that detriment occurs at an appropriate time. And an appropriate time is a period of time which is either in the worker's own time or when the employer has consented to the worker carrying out those trade union activities. And the key thing is, when you're taking industrial action, you don't fall within either of those protections. So as a result, the court declared that the Supreme Court ultimately declared that was inconsistent with Article 11, and as a result, the government is now taking the opportunity to introduce legislation that will afford protection for that. There's one slight fly in the ointment, in the sense that there is going to be a consultation on the types of detriment that will be protected, which sort of leads to open a question to the effect of, well, is it going to be the case that some detriments are protected for taking industrial action and others are not? Now, Section 146 doesn't make any distinction between the type of detriment. It just simply protects workers before being subject to a detriment. So it's unclear why there needs to be consultation on types of detriment, and that will presumably become clear once we see that consultation, which is expected expected early next year. Protection for taking part in, from dismissal from taking part in industrial action will be extended. At the moment, it exists for the first 12 weeks of industrial action, and then can be extended in certain prescribed circumstances, but generally doesn't go beyond the 12 weeks for the right of automatic dismissal. It will do within 2 months of the legislation getting royal assent, where you'll have automatic protection from unfair dismissal throughout the period of the industrial action, which is a very important change. So, just moving away from industrial action, and so we can see that there is some loosening of the regulations around industrial action, which should give trade unions greater leverage in the workplace. The next thing that the legislation said it would do would be to simplify the trade union recognition process. Now, there have been some positive developments in this area, and not least, you'll see at the moment, there is a requirement when a trade union seeks recognition to have at least 10% of the membership in the proposed bargaining unit. That is going to be, we think, changed through legislation. I use the word think because, again, there's going to be a further consultation on it. But the government made clear at the report stage that it thought that the 10% threshold was too high, particularly in fragmented workplaces, and it wanted to work with a percentage figure of between 2 and 10%, which ties in with the information and consultation regulations that require the same thing. As well as reducing the percentage of membership required in the bargaining unit, the law will also be changed so that a union will no longer have to show that it's likely to have a majority support in the bargaining unit. So you'll know at the moment when you put your application in, you're often, if you're over your 10%, but you're under 50% of trade union membership, you have to think about things like petitions to be able to show that the majority in the bargaining unit would support recognition. That will no longer be a requirement. So that's really important. It will make a recognition application much easier to get off the ground. Likewise, if a ballot is required, now going forward, there will simply be a requirement to show a majority. No longer will it be necessary that the additional requirement that exists now of 40% of the whole bargaining unit voting. That will no longer, voting in favour of recognition, sorry, that will no longer be necessary. So it will simply be a simple majority. A couple of other points just to make about the sort of requirements on the recognition provisions. One important change is that once you submit your recognition application, the bargaining unit is frozen on that particular day. So those individuals in the bargaining unit on that day are the only ones who would then get to vote in any subsequent ballot. That's important because often what's happening at the current time is sometimes the bargaining unit becomes flooded with new workers where employers deliberately recruit with a hope of influencing the outcome of the ballot by bringing in new workers who aren't necessarily members, well, who wouldn't be initially members of a trade union or may well not be members of a trade union. And if there's not enough time to sort of recruit those members, it then influences the outcome of the ballot. And that's been, as some of you will be aware, tactic used by some employers. That will no longer be permissible because the position would be frozen on the day of the application. Likewise, at the moment, a very controversial provision has always been around the fact that a recognition application can be barred where a union recognises a non-independent trade union, meaning that a sort of independent union cannot make a recognition application. That's going to go, so that provision will be repealed. So where you put your step 1 letter in saying this is a request for voluntary recognition, at that stage it will no longer be open for an employer to enter into an arrangement with a non-independent union with a view to stymieing the recognition application. So, I mean, that is an important change. The problem is that doesn't have retrospective effect. So employers could enter into those sort of arrangements. Now there is some evidence, that anecdotal evidence that's certainly been brought to my attention of some employers doing that. So that is an important point to keep an eye on. Finally, sorry, because I'm conscious not to overrun. Sorry, this is just to sort of conclude there, I think really was just to say that those provisions are, they are important in terms of making it easier to obtain recognition. Not necessarily that much of a simplified process. It's still a very heavily procedural in nature in terms of the steps you have to do, but at least there is definitely a reduction in the overall requirements to secure statutory recognition. Finally, this new right of access, which has been talked about in some detail. Now, how this right of access will work is really still not fully clear, and it's subject to a consultation that was released last month and which closes on the 18th of December. And I think that sets out some of the government thinking around this, but also makes clear that some points are undecided and that the government could still be influenced one way or the other. But in broad terms, what this is a sort of brand new right of officials of an independent union to enter into access agreements with employers. Access is both digital in nature and physical, and it has broad sort of parameters in terms of your access purposes. Can be to meet, support, represent, recruit and organise workers. The only thing that is deliberately excluded is that an access purpose cannot be to organise industrial action. But save for that, it's a very broad right. Now, the legislation the consultation sets out some guidance on how it envisages this will work. And it begins with a trade union making a request of the employer for access. And it sets out quite prescriptive information that will be required to go in that request. I'll not go through the list now for to save time, but you'll see there that there are a number of points that a union has to give information about, including the number of members it has in that workplace and that employer, or at that employer. Once the request is made, there's a fixed period in which the parties are given to seek to agree an access agreement. So what happens is initially the access request goes in, the employer then has 5 days to respond to the union's request. And it can either say no, or it can say let's enter into a negotiation period to try and agree the terms of those access. If there is a negotiation period, it's currently envisaged there'd be 15 working days of negotiation between the union and the employer to try and agree an access agreement. Then, if there's no agreement reached, either party can make a referral to the CAC. The CAC will then make a determination as to A, whether access should be granted, and B, if it should be granted, what terms of access, what the terms of that access should be. Now, one thing to flag up here is that it's a very tight time frame. So basically, any application to the CAC has to be made within 25 days of when the original application is made. So if you have the sort of 5 days for the employer to respond, and then the 15 days of negotiation, if that negotiation doesn't lead to agreement, the union would then only have 5 days, as is currently envisaged, 5 working days, to make the application to the CAC. If it misses that, it would have to start the process again. So that might be a point to factor into consultation responses. The CAC will then make a determination in regard to the access application, and effectively it has to do so with these access principles in mind. And again, I won't go through the list there, but you'll see they're broad in nature and are effectively designed to encourage the granting of access in most situations. So very much pushing the idea that it should be granted other than where a certain exception applies. But this is the bit that will become probably more contentious, is that the consultation seeks views on when it shouldn't be granted. And you'll see there that the government is proposing two situations where it believes it shouldn't be granted. One is where the employer employs less than 21 workers. One is where an independent trade union is already recognised. But perhaps more worryingly, it says generally an employer should not be required to allocate more resources to granting access than is necessary. So no requirement to construct meeting places or implement new IT systems, for example. But it also says that, you know, it welcomes evidence from any responders as to what other circumstances access should not be permitted. So a lot will depend upon, you know, what the regulations look like, in what circumstances access can be denied. Just very finally, to conclude, there is then enforcement provisions if the access agreement is breached, whereby, well, sorry, I should say that firstly, once, so the CAC will make a determination on the terms of access, and then if that agreement is breached, there is the right to go to the CAC to complain about the breach. The CAC will then make a determination, and if even once a determination is made, if subsequently the access agreement still is breached subsequently, either because the employer doesn't adhere to the terms or a third party is preventing access, then you can return to the CAC to make a further complaint, and the CAC has powers to order a fine. So there'll be no compensation paid to a union where access is you know, where access is denied or there is a breach of the agreement, but there is going to be provisions around a fine. The consultation talks about fines of a sort of initial fine of £75,000, and if for repeated breaches, it proposes a £150,000 fine. The risk being, of course, that some larger employers may simply pay fines rather than adhering to this legislation. But overall, a positive right that could make a real difference, provided that after the consultation, the sort of exceptions to the overarching right to grant access are tightly drawn. Thank you.